All right, so we're here for the 11 o'clock docket. One case is on that docket. It is 20 CA 1848, Chico versus Summer Lakes. Who's here for the plaintiff?
Good morning, Your Honor. Francis Facidomo on behalf of the plaintiff, Ms. Jeanette Ramirez Chico.
All right, and who's here for defendant?
Brooks Sable on behalf of the defendant.
All right, so these are defendant's motion. Defendant's motion for partial summary judgment as to defendant's duty to warn. It also looked like there was a motion in limine, but I didn't see the motion in limine in the court file. So I have two motions on my Jack's docket, but I only found one in the file.
So, Your Honor, the motion in limine was essentially, it was all in the same filing. It would have been paragraph E of the filing. It's actually a pretty simple issue.
Okay. All right, so go ahead, counsel. And you guys have scheduled an hour, so each have 30 minutes. Go ahead.
Yes, Your Honor. And because there's essentially three parts of this motion, before we get started, I think, would you like me to argue all three at once and then plaintiff,
yes.
with kind of, I'm sorry, no, yes or no?
Yes.
Okay. All right. So in this motion, Your Honor, there's essentially three arguments that are made. Well, just by way of very brief background in this case, this is a slip and fall case at an apartment complex. Plaintiff has alleged that she essentially fell, as a result of a dangerous condition that existed on one of the steps outside her apartment. In this motion that we filed, there's essentially three matters that we'd like to address. The first is summary judgment, partial summary judgment with respect to defendant's duty to warn based on the condition being open and obvious under the unequivocal testimony of the plaintiff. And the second is that there's no genuine issue of fact that one of the conditions that she has identified, these cracked or chipped stairs.
First of all, let me just stop you, counsel. Number one, we are proceeding under the new summary judgment standard. So it's not issues of genuine fact, it's issues of whether or not a reasonable jury would rule in your favor. Secondly, I just to clarify, I want to make sure that there's a number of bases for liability in the complaint. One is the failure to duty to warn, another is a failure to maintain. So my understanding of your motion is that you're strictly seeking summary judgment on the failure of duty to warn, correct?
Yes, Your Honor. With respect to those two duties, you're absolutely correct. We are not, arguing at this time that there is at least for purposes of summary judgment, that there's no duty to maintain, or that there's no violation of that for the purposes of summary judgment.
Okay.
The second part of the summary judgment motion does apply to both, but again, it's not summary judgment on the entire duty. It's summary judgment as to a specific claim that plaintiffs made where there's no evidentiary basis to support. But you would be correct. So just to kind of give a little bit of a procedural background, the plaintiff filed their initial complaint in June of last year. And in that complaint, they alleged that there was a dangerous condition. They didn't say what it was. They just said there was a dangerous condition that caused plaintiff to fall. I filed a motion to dismiss. Plaintiff amended her complaint, and the allegations in the complaint that was filed, the operative complaint September of last year, is that there was a faulty / cracked stairwell. So that was essentially the operative pleading as to the dangerous condition. Took plaintiff's deposition in February of this year, and we filed her transcript on March 12th of this year. Essentially, and I've laid forth the respective case law in the written motion, but obviously in Florida, there's two duties in a premises liability case, which this is. There is two duties: duty to maintain, duty to warn. The duty to warn is of any known dangers that the defendant either knew or should have known or had greater knowledge of than that of the plaintiff. At her deposition, plaintiff testified that she fell on the second or third step of, the staircase at the entrance staircase outside of her apartment. None of that is in dispute. None of that, the location is in dispute. Plaintiff produced a photograph that was taken by her husband, which she authenticated at her deposition that was the condition that caused her fall. It was that was the location, and that was the observed condition that would have caused her fall. So again, none of that is in dispute, and that's been attached as, I think I referenced it as Exhibit A and accidentally attached it as Exhibit B of our written motion. We also attached another photograph of the staircase just so there's no ambiguity, but none of that is in dispute. So in starting with the duty to warn, basically, of course, I was going to make clear that the court already established that this has nothing to do with the duty to maintain. We're just arguing that it was open and obvious. And this is based on the undisputed testimony that plaintiff has provided. Very simply, she testified that she had previously, prior to the incident, reported this condition, and she testified that she had actual knowledge of this condition. In fact, she testified that prior to the incident, on several occasions, which is her testimony, she warned her son and her husband about this exact condition which she felt. So I have supplied the respective testimony, Your Honor. I think the kind of citing it starts on page 28, paragraph 23. And if you look at that testimony, it kind of goes through exactly what she testified, exactly what kind of knowledge she had, and clarifies and supports everything that I've just said. I don't think any of that's in dispute. The plaintiff certainly hasn't rebutted or attempted to rebut that in their written motion that any of this is in dispute. I will read in the most probative testimony, starting on page 40, paragraph 16. How about conversations with your husband and son? Did you ever have any conversation with them at any point prior to the incident about there being something wrong with the front staircase at building 12? Yes, I have told them to go up and down the stairs slow and carefully because some of the steps were loose. Do you know approximately when you would have instructed your son and husband to do this, to go up and down the stairs slowly? No, I don't recall. Do you know approximately how many times you would have made this representation to either your son or your husband? Several times, I told them. So respective to the duty to warn, the undisputed testimony shows she had actual knowledge of this condition. She warned other people about this condition. So there's essentially no reasonable jury could argue that the condition was not open and obvious. And if it is open and obvious to her, someone who has actual knowledge, then there is no duty to warn. The only thing that would need to be determined is that other duty to maintain. Now, respective to the second matter, essentially plaintiff, again, in her operative pleading, they allege that she alleged that she fell as a result of cracked, faulty stairwell. At her deposition, when it started out, kind of changed her testimony a couple times, but essentially she testified to two things, arguably only one thing. But giving the plaintiff the benefit of the doubt at this motion, she testified that she fell as a result of the stair being wobbly, stair being loose, and the stairs being cracked and having a chipped edge. We're not contesting that. We are contesting that the stair was loose or wobbly, but for the purposes of a summary judgment motion, we're not asking the court to make a decision here today. That's not what this motion is, that the stair was wobbly. She's made that testimony. For the purposes of this motion, that's not something that we're attempting to hold, at this point, that a reasonable juror couldn't decide. The part that we are contesting, that there is no factual basis, there's no evidence to support, no reasonable juror could decide, is that she tripped or fell as a result of specifically these cracks or this chipped edge in the staircase, based on the authenticated photo and her undisputed testimony. So very simply, I provided the testimony authenticating it. Again, I don't think any of this is in dispute. It shouldn't be. That she authenticated. There was a photo she produced, and we showed that photo. And essentially, after authenticating the photo, marked up the photo because it was done by Zoom. And the photo shows we circled the areas. It's undisputed. This photograph is the condition. This is the location where she's alleging she fell. There's obviously other photographs that show there's nothing observably wrong with any other stairs, but I don't think it's necessary to go into all that because she's already unconditionally testified this is where she fell, this is what caused her fall. So I provided that photograph as an exhibit. Admittedly, looking at it today, it's a little bit more blurry. Is the court okay if I share the screen? It might make
that's
it
fine.
easier.
Yeah.
So, Your Honor, if what I'm sharing on the screen is the photograph of the location that plaintiff has testified where she fell and the conditions that would have caused her fall. Again, notwithstanding the step being loose or wobbly, which is something else. And I've included all of that testimony just so there's no issue. But I would like to read, kind of the Well, before I get into that, Your Honor, I'll show the court. This is the photograph she authenticated. After that, we marked up this is the marked up photograph. And this isn't, I didn't mark this up after the fact. This was marked up at her deposition. This is what she confirmed. This is what she testified to. The areas circled in red are the cracks that she's referring that caused her fall. And the area that is circled in yellow is the chipped portion, the chipped edge that she's alleging caused her fall. Very simply, the argument, and I can read in some testimony just so there's no, there's no confusion, Your Honor. At least starting at page 122, I'm not asking about the step being wobbly. I'm asking about the actual cracks, chips, broken pieces within the step, which you have testified contributed to your fall. My question is, how did the areas that are identified on the red circles, how did those conditions contribute to your fall? Because that is what you call it, cracked or chipped off, and it causes the foot to kind of get stuck in it, and the step loses strength because it's not stable. Essentially, this is the only substantive answer that was provided as to how these particular conditions, at least how the conditions circled in red, these arguable cracks would have caused her fall. She said her foot got stuck in it. And she literally said her foot got stuck in it and it caused her to fall. It's our position that if you look at the photograph, you do not need an expert to explain or provide any additional evaluation of this is not an inherently dangerous condition and it could not have physically actually caused her fall. She's not alleging that she slipped on a transitory foreign substance. She's alleging she slipped, at least partially, one of her allegations, she slipped as a result of cracking. Another allegation, she slipped as a result of the chips of the edges of the stair being chipped. And then the third, that she slipped as a result of it being wobbly. So starting with the areas in the red circle, it's plain and obvious that these are, they're not cracks that are even on the surface area of the stairs. And if you zoom in, Your Honor, just so there's no confusion, this is the crack that she's testifying would have caused or contributed to her fall. And it's our position that the undisputed photographic evidence in her testimony establishes that it's physically impossible and that no reasonable juror could decide that, this condition right here or over here could have actually caused her fall. The second part of that, obviously, is a chipped edge. And very clearly, while a chipped edge could certainly, be considered a dangerous condition under certain circumstances, if this would have existed in a different location, if she was arguably walking up the stairs. But that's not what happened here. Her testimony, again, undisputed, she was walking down the stairs. She testified that her right foot bent backwards and she fell. There is no reasonable juror that could look at a chipped edge underneath the stairs. There's physically no way that her foot could have even made contact with, or otherwise touched this area of the stairs. It's literally underneath the stairs. So what we're arguing is that neither one of these conditions, no reasonable juror could find that either one of these conditions would have caused her fall. I don't think it's necessary to get too much into it, Your Honor, but in addition, I'll just kind of show another photograph of the, I'll pull it up, of the staircase. This is the staircase, this area right here, that's basically the zoomed in area. That's the step that she would have fallen. If she's walking down the stairs, the right side of her is the wall. So it's the left side, which is the area where it would have existed. She testified that she would have stepped on or got stuck in with her right foot. Obviously, it's all the way to the left. Again, I don't think this evidence collectively, any reasonable juror could decide that this, underneath chipped stairs or these arguably hairline cracks could have contributed to her fall. So that is essentially the argument with respect to that portion of the motion. And the third part of the motion is really just a motion in limine, and that's basically plaintiff's testimony. I'm gonna take it off screen share. The plaintiff's testimony that, well, actually, let me just backtrack, Your Honor, just so I don't miss anything. As the deposition went on, plaintiff seemingly admitted, she kind of contradicted her prior testimony, but she actually testified and admitted that the cracked or chipped stairs didn't actually contribute to her fall and that she's not actually alleging that. I will read that testimony starting at page 126 of her deposition transcript, paragraph 14. Outside of causing the staircase to wobble, is there any other way you believe that any of the conditions identified in Defense Exhibit 5, the 2 red circles and the yellow circle, do these conditions contribute to your fall in any other way other than you believing that they caused the staircase to be wobbly? No. So again, I asked her, she previously said this is what she alleged. And then she previously had been testifying that her foot got stuck in it, that it didn't look right. And then she seemingly testified towards the end that no, they didn't actually cause her fall. They just caused the stair to be wobbly, which caused her fall, which leads to the third part of the motion. The third part of the motion is not a summary judgment. We're not asking the court to make a determination, decide an issue of summary judgment. It's merely a motion in limine that plaintiff has made an improper opinion. Her testimony that, I'm saying it's not any evidence, but it's her testimony that these conditions that were identified, was shown before, these arguably cracks and this chip portion, that this would have caused the stair to be wobbly and be loose. And very simply, Your Honor, that's an improper opinion. It's pure speculation. I've asked her, she didn't have any evidentiary basis. I asked her, what's the evidentiary basis for that position? And she could not provide one. I've included that testimony within the motion. Asked her, she didn't have any specialized training, any technical training, no experience working with stairs, didn't even do any independent research as to the causation, as to the stairs and how they're fixed and whatnot. Now, I can tell the court, I'm not asking the court to accept this because we're not moving for summary judgment. But the argument that's essentially been made in plaintiff's written motion is that, well, this is obvious that, if there's a portion of the stair that's chipped, it's obvious it would have caused the stair to be uneven and wobble, so she can make this opinion. Again, I'm not asking the court to accept this, but that's actually patently wrong. I've handled a lot of these cases with this exact.
And it's contrary to the case law. I mean, you
Yes.
can't just say because something exists that therefore there's causation.
Yes, Your Honor. I've cited that case law. I think the most probative one would be Mills versus Red Wing Carriers and Zwing versus Hedinger that basically say exactly that. A plaintiff cannot make an opinion as to causation just because it exists, therefore it caused that. This is even taking a step further because she's not saying that this condition caused that. She's saying this condition caused another condition which caused her fall. So I think, again, I think it's a pretty simple motion limiting, but it's merely that it's an improper opinion and it should not be allowed to make that testimony excluded at trial. So that would sum up the arguments, Your Honor. So, plaintiff seems to be enough time. So just in summary, obviously there's a motion for summary judgment on the duty to warn based on actual knowledge and based on the fact that she was warning others of this condition. A summary judgment that the cracks or chipped stairs, the conditions which she unequivocally authenticated.
You know what? You don't have to summarize it for me. I heard.
All right, I apologize, Your Honor.
That's okay. All right, Ms. Fresadoma, go ahead.
Yes. Good morning, everybody.
Mhm.
So, Your Honor, it is our position that, and I'm sorry if my camera's out.
That's okay. Don't worry about it.
It's our position that defendant had a duty to warn. Now, what caused my client to fall was a stairwell. This is a stairwell where she resided. She had some awareness that some of these steps on the stairwell were unsteady and wobbled. She wasn't able to really testify as to which exact ones they were. But on the day of the accident, she did testify that the one in question, the photograph that we saw, was the step that led to the fall. Now, again, Your Honor, her testimony continuously was that the step was unsteady and it caused her to fall. Now, arguably, she may have forgotten which ones of the stairs were unsteady. She could have been in a rush that day. She may have forgotten that the step was defective.
Okay, let me stop you for a minute. You need to be citing to something, and I also noticed that you did not file an affidavit on her behalf. So I don't. You need to let me. You can't just kind of cite these types of things without some, without citing where I'm finding that in the record.
Sure, Your Honor. Thank you for the clarification. Now, it's our position that because of the dangerous nature of the step, that the defendant should have anticipated that it caused an inherent risk, and therefore a warning at a minimum should have been done. Now, again, this was a stairwell that was located at the front of the building closest to the parking lot, where the residents used to park their vehicles. Now, the steps were not only a danger, obviously, to my client, but to all of the residents that live there. Now, it's again, Your Honor, a faulty stairwell. This is what we're talking about, a faulty stairwell. Undoubtedly,
we're really talking about a faulty stair, not a faulty stairwell.
Well, a faulty, step in the stairwell.
Right.
This creates unreasonable risk of harm that would have certainly required that additional precautions be taken for the safety of not only the plaintiff, Your Honor, but the other residents. Now, arguably, a wobbly, unsteady step is not an open and obvious condition. If you take a look at her testimony, specifically on page 12, when she's asked, the question is, let's start with the first part of that testimony. You said it was wiggly and wobbly. What about this photograph depicts that the staircase was wiggly or wobbly? Plaintiff answers, the thing is, you wouldn't know that from the picture. You would only know if you stepped on the step. Now, as you can see, Your Honor, from the picture that was showed by defense counsel, there was significant cracking at the top of the step, and there was a portion from the bottom of the step that was missing. Again, time and time again, when my client was asked in her deposition, and I counted at least 10 separate questions about what the mechanics of her fall, she continually stated that the step was unsteady and wobbly. Now, again, it's our position that Summer Lake should have anticipated that faulty wobbly steps would create an unreasonable risk of harm. Now, also, Your Honor, just because she was aware of the dangerous condition, it doesn't negate the potential for liability on the defendant's part. I mean, it may be relevant towards a determination of comparative negligence. Now, as we stated in our response, Your Honor, defendant should not be allowed to ignore complaints, fail to investigate a potentially hazardous condition for clear and latent dangers, and then attempt to defend an injury claim by saying that they had no duty to warn of an open and obvious condition and then just simply ignore it. Now, also, Your Honor, when it comes to negligence actions, the courts have continuously ruled that the facts should be determined in the light most favorable to the non-moving party. And if there's a slight doubt regarding the existence of those issues, that summary judgment isn't.
Oh, but that's the old standard. That's not the standard we're using today.
And now I'd like to address the issues in the motion to eliminate or exclude her testimony. Now,
sure.
She again, throughout the deposition, and I believe this was about a 6-hour deposition, she was asked continuously what caused her to fall. She specifically, I mean, I could go line by line, page 44, page 45, page 46, page 78, page 113, page 114, 117, 123, 124, 125. Again, all this testimony relates to as to the mechanics of her fall, where she was consistent in that it was the unsteady, wobbly nature of the step that caused her to fall. At one point, at one question, she was asked about the cracks contributing to the fall. And I think just by looking at that photograph, Your Honor, the cracks indicate that that top portion of the step was uneven. It does not seem implausible that you would step on that crack, kind of lose your balance, and then end up falling, especially since there's a portion at the bottom of that step that's missing. And again, that's not the photograph didn't.
Okay, so but here's my question, counsel, and I reviewed your transcript quickly, so you know it better than I do. But I didn't see any place in that deposition where she testified that, yes, I stepped on the step, I felt it wobble, and then I fell. Is there any testimony to that effect? I don't think so. I think what she says is the step was wobbly and therefore it must have caused my fall. That's a completely different statement. She can testify about the facts and her experience, but she can't testify as an expert. So if it's pure speculation, she cannot testify about it. But if she's testifying, which again, I did not see in the transcript, if she's testifying that, yeah, here's the mechanics. I put my foot on the stair. I felt it wobble. I then fell. She can testify about that, but she can't then draw the conclusion that that's what caused it. So
Well,
is it someplace in the transcript that I missed?
Yeah, let me open that up 1 second. If you go to page 44, starting in line 3, the question is, I'd like to get back to the incident itself. Why don't you tell me what happened February 13, 2019?
Mm-hmm.
Well, I was going down the stairway and I was going down the stairs and the step was not fixed. It was unsteady. It wiggled and I fell from it and landed at the bottom of the stairs.
So she can testify about that. But she can't testify that that is definitively what caused her fall, because she's not an expert.
Understood, Your Honor, and we'll highly stipulate to that, and defense counsel has every right to object if but she will not be providing any sort of expert testimony. This is just her firsthand account of what happened to her. This is what she experienced, and this is what she thought caused her to fall. And continuously, repeatedly, she states
she can't testify about what she thinks caused her fall. She can testify factually, for example, in that answer on page 44, exactly to the sequence of events that occurred and what her experience was, because she's a fact witness, not an expert. But she
understood, Your Honor.
She's not an expert.
Understood, Your Honor.
She's not an expert.
She is not.
Yeah. So, okay. Anything else?
In conclusion, Your Honor, we do think that they are genuine issues of material dispute at hand. Defendants should have had a duty to warn my client as far as the defective and dangerous nature of these steps, and we're asking that these issues be properly decided at trial.
All right, Mr. Sable, anything you want to respond?
Yes, I think the only rebuttal that I'll provide, Your Honor, is really to the second issue, respective to the opposing counsel essentially saying that there were cracks all over the top of the steps, and it's our position there isn't, and the undisputed evidence shows that. And I understand all those arguments can be made, and oftentimes we don't have that evidence, and we cannot narrow it based on the testimony as much as we can here. But here, everything has been narrowed. This is the condition, this is the step, this is the location, and they're saying that there's cracks all over the top of the steps, and they're not. We can use our eyes to look at that. So I don't want to beat a dead horse, but if you just share the screen again, Your Honor, if you're looking at that, first of all, she testified that there were no cracks in the top. When I circled those, the areas that I circled and showed to her,
so
right
you just
here,
want me to find that there's no cracks in the top of the stair? I thought she wanted me to find that the cracking could not have caused the fall.
Yes, Your Honor, I do. I'm just responding to plaintiff's argument. I mean, essentially the argument that plaintiff just made is that it's obvious the cracking caused her fall. There was cracking on the top of the steps. In the event, in abundance of caution, there's any confusion, I'm just kind of rehashing that is not what the evidence shows. That's really it. Very simply, again, the cracks that were shown, no reasonable juror could look at that and decide that is what caused my fall. Your foot got stuck in there. I mean, I don't think there's any cracking on the top of the steps. I don't think her foot could even make contact. If there is any at all, we're talking hairline cracks. That is not something that a reasonable juror could find would have directly caused or contributed to her fall. Their claim is that the steps were wobbly, and essentially the purposes of all of this motion is to limit it to that. If that's what they're alleging, not to cause any type of confusion on any other issues based on, again, the undisputed evidence.
All right, well, I am going to grant your motion for summary judgment, for partial summary judgment on the duty to warn and the condition being open and obvious. I would note for the record that means that then the remaining duty, which is the duty to maintain, is still at issue. Secondly, I am going to grant your motion in limine with regard to the plaintiff's opinion that the cracking or wobbliness caused her to fall. She can testify, as set forth on page 44 of her deposition, that she's going, again, factually what happened. Apparently she felt it wiggle and then she fell. So she can testify about that, but she cannot offer an opinion as to what caused her fall. She's not an expert. And lastly, in terms of your request that the court render summary judgment on the issue of that the cracking could not have caused the fall, I'm going to deny on that basis. You also need an expert. So again, what's good for the goose is good for the gander. You can't ask that I require them to have an expert pursuant to the law and then tell me, oh, look at this, judge, we don't need an expert to tell you that either there's no cracking on the top, or that the cracking could not have caused the fall, or that any wobbliness could not have caused the fall. So I'm denying on the third or the second ground, and granting on the first ground, and also on the motion in limine. So I'll
Yes,
need an
Your
order from you, Mr. Sable, after you've circulated it, sent to my office email address and Word format, please.
Yes, Your Honor.
When are you guys set for trial? I'm just looking at your file here. Looks like November.
November.
Okay. And then you have this set for arbitration, it looks like.
Yes,
Yes.
Your Honor.
Okay, good deal. All right.